Thank you for inviting me to speak on the rise and fall of Voting Rights Act of 1965. I'm not going to take you through the history of voting up to 1965, but consider this. Only landowners were able to vote originally. Most men could vote, no women could vote, except in some special elections in the state. Blacks had votes in a few states, but for the most part, voting rights were not guaranteed in the Constitution, and voting rights were really codified for the modern day in 1965. The Constitution provides in Article 1.4 that each state legislature has the power to set the times, places, and manner of holding elections for the U.S. senators and representatives. But the Congress may at any time, by law, make or alter such regulations. After the death of so many civil rights workers in the South, the marches on Selma, the passage of the Civil Rights Act without having any impact on voting rights. Finally, in 1965, the Voting Rights Act was passed. The importance of the Voting Rights Act cannot be understated. In Section 2, it made it clear that no voting qualification or prerequisite, such as literacy, to voting or standard practice or procedure should be imposed or applied by any state or political subdivision, in other words, a county or a city, to deny or abridge the right of any citizen of the United States to vote on account of race or color. The importance of preclearance in Section 4 of and 5 of the Voting Rights Act meant that the federal government, through a formula included in the act, would review all policies and procedure changes before any act could be implemented in any of the covered states. The covered states were those who met the formula for discrimination prior to 1965. The direct result of the Voting Rights Act was immediately obvious. Mississippi, by example only, black voters went from 6% to 59% registered by 1969. Look at Congress. They had 6 blacks in 1965, 13 by 1971. The Justice Department reviewed 4,500 to 5,000 claims a year, and 14,000 to 20,000 voting changes had to be approved before any of these states who were covered by preclearance could make a move. By 1966, a quarter of all new voters in the South were black. By 1966, only 4 out of 13 southern states had less than 50% of eligible black voters registered. An immediate effect of the Voting Rights Act. The Voting Rights Act was immediately successful and was augmented 8 times between 1965 and 1993. For example, the preclearance formula was updated in 1970 and 1975. Requirements for foreign language ballots, for voter assistance, for voting rights for people with disabilities. And you know the motor voter law, where if you went into a state and changed your DMV, you could, your driver's license, you could immediately fill in a voter registration form. These were very impactful. And the Voting Rights Act itself was extended in 2006 for 25 years with a sunset clause. This slide shows which states were actually covered in 2013 by preclearance requirements and going to either the federal court or to the Justice Department before any one of these states in purple, counties covered in red, including Kern County and 3 other counties in California, and townships in Michigan, no changes could be made till they had prior approval. That was the situation in 2013. And then the Supreme Court, in the famous Shelby County versus Holder, ruled that the formula in Section 4B of the Voting Rights Act was unconstitutional. And without 4B, then you would have no preclearance. Chief Justice John Roberts said that the Voting Rights Act was 40 years old and was no longer responsive to the current needs. And in fact, he commented that so many black voters had registered to vote, there was no need. And then he went on to say that it was an, quote, impermissible burden on the constitutional principles of federalism and equal sovereignty of the states, close quote. And Justice Thomas, in his concurring opinion, thought that Section 5 itself, which was preclearance, should be unconstitutional. You probably know what Justice Ruth Bader Ginsburg wrote in her minority opinion, but she was so clairvoyant. Quote, throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. The immediate impact of Shelby cannot be minimized. 1,688 polling places were closed, and you'll see where they're located on the map. Oh, and they were often on college campuses where liberals and pro-integration people resided. By 2019, 35 states had implemented stricter voter identification requirements, and note where the heaviest were. Photo ID required in all of the previously covered states. 20 million voters were purged since Shelby County. Voting laws enacted in 2021 restricted or expanded or both, but in fact, many were quite onerous. And you remember that in Georgia, for example, they made it illegal to hand water out. But the Supreme Court continues to attack the Voting Rights Act. And in 2021, in a landmark decision called Brnovich versus the Democratic National Committee, and Indian reservations, volunteers were stopped from collecting ballots from people living as much as 300 miles away from the precinct. and to deliver them to the precinct. And they stopped counting the ballots of people who actually went to a precinct and voted, but were in the wrong precinct. Not that they didn't have the entire ballot correct, but because they were not in their own precinct, they were not allowed to vote, and they threw those ballots out. Be clear, in California, you can vote in a precinct in your county that is not your own precinct, and that vote will be counted. If you voted for the wrong school board, that vote would be removed. But now with vote centers in California, you're actually printed off the correct ballot for you to vote. The Ninth Circuit, which was reviewing the case before it went to the Supreme Court, had ruled 7-4 that Brnovich was an unlawful violation of Section 2 and that it had an impact on Native Americans, Hispanics, and African American voters, and that it was diluting the voting rights of these people. And the Supreme Court did exactly that. The Supreme Court had earlier in 2010 ruled in Citizens United that corporations and unions could support candidates openly. And what that resulted in was huge amounts of money going in to target Black voters and writing scurrilous ads which were untrue, attacking the integrity of candidates. In this October 22 term of the Supreme Court, two important cases will be considered. Merrill versus Milligan has already been heard, and they're looking at Section 2 of the Voting Rights Act to determine whether it can be found unconstitutional when it is ordered by the federal district court to provide a fair balance for 26% of the Alabama of the voters who are Black to have fair representation in the redistricting. And it was argued by Alabama that that was racist and therefore was outside Section 2 and unconstitutional. The second case to be heard is Moore versus Harper, and this is truly worrying because it has a theory called the independent state legislature, that state legislatures have more power than their state Supreme Court when it comes to election laws when Congress has failed to act. And this case is considered by legal scholars to be the most important case being heard by an inadequate Supreme Court who are not based on precedents or the rule of law. So how do we see this? National Voter Corps has been working to try to draw the attention of advocates to the Freedom to Vote John R. Lewis Act, which was passed by the House, which would make all the Supreme Court decisions be reversed by virtue of congressional act. But it's being filibustered. The filibuster was derived from a Dutch word meaning looter or pirate. It's not in the Constitution, and in fact, the lack of having a majority vote to end a debate in the Senate was accidental. It was first used in 1839 and is rarely used, and the times it has been used are for such things as not passing laws about lynching, voting rights. Now it's being used to stop the 1965 Voting Rights Act from being reenacted by the House. It takes 60 votes to pass legislation in the Senate. Already there's one state, California, has 39 million voters, and 5 states, the 5 smallest, have 10 senators and have 3.5 million voters. So California is disproportionately represented in the Senate, and you feel the weight of this when you add the filibuster. The exemptions to the filibuster include Supreme Court nominations, federal executive positions, such as nominations from the president for his cabinet, and budget reconciliation. We need to reform the filibuster. We need to pass the John Lewis Act, voting rights. Let's see why. Because the John R. Lewis Act addresses preclearance, voter protections. It gives more power to the U.S. Attorney General to send in federal observers, and it talks about election integrity. The importance to passing this act is your zip code will not control how you vote. It removes gerrymandering. It protects election integrity. And we would have these examples: automatic voter registration, early voting. Voter ID requirements would have specific limitations by the state on what they can require. Felons would have uniform rights. Same-day registration. It would revise Formula 4 for preclearance so that immediately, if this were passed, California and those states that are in green would be covered either by county or by would be covered as a whole. New York, for example, would also be covered because it has been gerrymandering. Virginia would be covered, Texas, Alabama. So the solution is for you to call the White House, call the Senate, call your friends and tell them, listen to this, find out what's going on, get yourself organized, protect our right to vote. Here are organizations you can join to protect voting rights, but of course the ACLU is a major player in this field. I'm very proud of the work they've done. Here are the states that have been implementing voter suppression, and consider the brave people in the Ukraine who are defending their democracy. We in the United States need to protect ours by standing up for voting rights now. There are films you can watch. I have an appendix here. I just want to thank you.